That is all, Your Lordship. I requested that at this point, Your Lordship, my clients be given a bit of time.
Enough with the lies. Your clients are the abductors. Go tell them to produce the second petitioner in court.
Your Lordship, that is all.
You must stop the abductions. You must stop extrajudicial killings. We will not come here to listen to your stories. You have abducted someone. His family is crying, and you are here telling us stories. Enough is enough. The extrajudicial killings and disappearances must end now. We must stop this madness. We must stop these evil things you are doing to us. It is not right to abduct someone and not present them to court. And you are here telling us stories about... Let me speak. I will sit down. This is not right. Why should they abduct someone and instead of producing them to court, they come here to start telling us stories about, I don't know, my client did this. Your client what? Then what are we supposed to do? If the people who are supposed to protect us have turned out to be the greatest threat to our security.
Can we proceed?
Yes, ma'am. My Lord, we have heard the counsel for the respondents. I want to begin by referring you to the wording of order number 5. And if you allow me, I'll read it in extenso. That the Inspector General of Police and the Director of Criminal Investigations were named as the first and second respondents, and also the fifth and sixth respondents in their personal capacities of criminal investigations do attend court to show cause why Diang'ui Kenyagia, the second petitioner, should not be produced in court or released. It is clear, my Lord, that in the absence of Diang'ui Kenyagia being produced in court, the Inspector General of the Police, the first respondent, and the Director of Criminal Investigations, the second respondent, ought to be here before you. Nothing whatsoever has been said about their blatant disobedience of the court order. There has been no compliance, absolutely. In other words, they are not taking the orders of this court seriously. And that does present a very big problem. Secondly, even if we were to believe them, and we don't, that they do not have him, their business is to investigate and know about the welfare of Kenyans. That's why we pay them, that's why they exist. Diang'ui went missing on the 21st of last month. Today is the 1st. So we are talking of 10 days ago. His family did not just complain to the media. They went to Kenol police station and reported on the 23rd. And that is in the affidavit of Lawrence Muturi. The first affidavit, the supporting affidavit. So from the 23rd to today, there is nothing in the replying affidavit of the respondents of Samuel Itegi to tell us how far they have gone with the investigations and what they have done, if at all, to find Diang'ui Kenyagia. This matter has been very, very public, to the extent that yesterday, my Lord, the DCI, the second respondent, at 4 p.m., long after you had adjourned the hearing and given your orders, Therefore, we assume that he knew he's supposed to be in court today, decided to appear before the public and deny having Ndiang'ui Kinyagia in his custody. So he will deny publicly, but he will not come to assist the court to reach a decision. And he will deny publicly in a matter that is sub judice. A very, very disturbing feature of the affidavit of the respondents is to be found in their annexure, their sole annexure to their replying affidavit, which is the inventory of the things taken from Ndiang'ui Kinyagia's side. It's page 10 and 11. If you look at that, my lord, and look at our annexure attached to the affidavit, further affidavit of Florence Muturi, sworn on the 27th day, yesterday, not yesterday, 27th day of June, which was Monday, where we attached as FM1 the inventory taken of items taken from Ndiang'ui's house. You will, on the face of it, discover that the annexure SI1 of the replying affidavit of the respondents appears to be a forgery. And which makes the second respondent.
Which one are you referring to?
I would request that my lord has both of them. The one attached to the respondent's replying affidavit, the first page, and the one attached to our further affidavit, floor FM1. Ours is in color. Theirs is in black and oh, I'm told it's also in black and white. It's my copy that is in color. If you look at those two, my lord.
Just give me a minute.
Okay. Also, here has this one does not have recovered.
Yes, continue.
My Lord, if we start with the date, oh, sorry, may I seek your indulgence to draw your attention that Kipe Mungai has joined our team, and also that Monday opening, I'll be assisted by Abna Mango and Willis in responding. My Lord, if you look at the date, on the one by the respondents, it is indicated 21st with ST on top of 21st.
So that is the one from yourself?
From the respondents. I'm beginning to show the differences. Why we conclude, we say it is a possible forgery. If you look, if you compare with the one by the in support of the petitioner's affidavit, the date 21st has no ST. It's just 21st June 2025. A further difference, 2025 on the petitioner's supporting affidavit is typed, while the 25...
I thought you go over the respondents.
Okay, let me do that.
And when you are done, you now come to the petition.
I'll do that.
So that there is...
It's methodical.
Yes.
Okay.
So
the differences, we have noticed several
the date
differences.
21st.
I had ST to signify 21st.
Yes.
And the date 2025, 20 is typed, 25 is written by hand.
Yes.
Then it has 6 items. It ends at number 6.
Yes.
Then it has the name of a witness, Jane Jango. Then when you come to the respondents, not to the respondents, to the applicant, to the petitioners.
Done with the respondents?
I'm done with the respondents.
So the differences are?
The differences are
Date
21st does not have an ST, and the year.
6. I'm done.
And,
I've marked 21st ST.
yes, and then the 2025 is typed wholly. It's not written by hand. Unlike theirs.
I'm on the respondents.
Oh, we finished with the respondents. I've now started with ours.
So I'm confirming that I got you right.
Yeah, the differences are
21st
ST and 25 written in pen instead of typing.
Then the items are 6.
Are 6.
The witness, Jane
Jango. Yes.
Okay.
Those are the 3 notable things in that one. On the one by the petitioner,
Yes.
the date does not have ST, and I've just noticed one more issue, but I'll mention it. Doesn't have ST, and 2025 is wholly typed, not written by hand. And this particular, if you allow me to point a difference I didn't point on the other.
No, let's go.
All of it, yeah.
No, let's go the way you went.
Okay, and then I come back.
Then you now
Come
highlight
back.
the one you think
Okay.
is outstanding.
Inventory of items above the date taken. Inventory of items taken. It says ceased from inventory of items taken, stroke ceased for the purpose of investigations.
Yes.
Note that one. I'll come back to show a difference somewhere else. Then we go to the items. My Lord, this one has 7 items. That is the petitioners. And there is overwriting
on the item numbers. Number 6 is cancelled because number 5 appears to continue up to number 6, so it's cancelled.
Number 7 is cancelled.
Number 6 is cancelled. Number 7,
Item.
the numbering. The numbering. You can see a cancellation on the letter 6 and then an imposed writing on the number below to be 6. A cancellation below number 6, the imposed number 6, and then an imposed number 7. So the petitioners has 7 items and the numbering has been changed.
Yes.
Then we go.
What about witness?
Witness, it is cut, but it appears, the signature appears to be there. This one, yeah. Signature. But there is still the layout appears different at the end from this other one. Where is it? And it has the following words. After number 7, it has recovered from name House of Kenyagia Diangui. You can see House of Kenyagia Diangui. .096 is not there. Sergeant 096. A feature that is also will distinguish the petitioners is the item number 7, which talks of okay. Item number 7, the difference is actually not the writings, is that on our annexure, the petitioner's annexure, item number 7 is on page 1. There is no page 2 of the inventory. It's whilst...
So the petitioner's documents have only one page?
Only one page.
No? One page.
Whereas the respondents is 2 pages. You see that number 7 is on page 2. Ours, it's all on 1 page. You will also notice. Oh, this is the time. Yeah. But you see the one with the coat is black and white. Yeah, we can leave it for now. So what we are saying... So we do not have the signature of Oya.
Yes.
This one is not anywhere here.
Yes. Yes. It's not there.
And this is ceased. This is sin. Where did I see sin? No. No, the word sin. This is sin. It also has the word sin. This one. No.
Yes.
This.
Yes.
The last distinction between the two I would like to point out now is on the respondents. On the respondents, if you look at below the Directorate of Criminal Investigations, it is inventory of items taken, seized from the suspect, seen for the purpose of investigation. Now, if you look at the petitioners,
The words inventory appear at the top.
the word that is not similar in both is the word sin, as in sin of crime. Whereas the respondents, one, in that heading, has the word sin, and these are typed. The word sin does not appear on the copy of the supporting affidavit of the petitioners. Yeah. I'm not a document examiner, but even the writings appear different. So with respect, we suspect that the exhibits annexed to the replying affidavit of the respondent, Kopro Itegi, are a forgery. And following the press conference of the second respondent, with respect, we see him as a person of interest, and we would be happy to cross-examine him if he was in court. I do not think, my Lord, that you'll be able to get to the bottom of this matter without his personal appearance and without the appearance of the Inspector General. Apart from the need to comply with court orders, law enforcers cannot become lawbreakers and fail to comply with court orders. As I yield to my colleagues, my Lord, you will note from the documents, and I've already stated it, that Diang'ui Kenyagia has been missing for the last 10 days.
Yes.
I just want to say, my Lord, with respect, that it appears, because this is not the first case, that detention without trial is being returned. Kenyans refer to the KANU era when it happened as the dark days. Those dark days, my Lord, at least the state used to acknowledge it's holding somebody by whipping out a detention order. The detention today, extrajudicial detention, is accompanied by a denial. I'm just wondering aloud, why would we have documents that are so dissimilar that are most probably a forgery? We need an explanation from the two individuals, Inspector General and the Director of Investigations. And I would like to say that any alleged matter said by the caretaker who has not sworn an affidavit and who appears to have made a general statement, not a statement to the deponent. If you look at paragraph 14 of the respondent's affidavit, it says, the said caretaker informed officers that the second petitioner had left the house earlier in company of another man and 2 unknown ladies. He doesn't say he has been told by her, which he verily believes to be true. It's a marketplace statement. He said to the officers, this is hearsay, should be expunged, unless if the lady herself swears affidavit and avails herself for cross-examination. What if the 2 others he left with were an advance party to abduct while the others come back and search? Those are things we can never know. I sit just down with one proposition. The coincidence of the house being broken into by the police, which they now admit, and my colleagues will be dealing with the illegalities of that, and his disappearance, and the conduct of the DCI and the police generally in this country in matters relating to abduction, leads to the inescapable conclusion that indeed they arrested him and then ransacked his house. I yield to my colleagues.
Harold, very briefly.
Yes, Mr. Chairman.
No, I start from the point that I assume that the respondents recognize that we are in a country operating under the rule of law. And if they accept that fact, then a competent court having made an order, I've never seen orders that are so express and explicit like this one, directing the IG, Mr. Kanja, and the DCI, Mr. Min, to produce Mr. Ndiangui Kianyagia on the 1st of July 2025 at 11 a.m. That's the first part of that order. It is 12:43 at the time I'm speaking. And the 2 gentlemen have not produced Mr. Ndiangui Kianyagia. This court specifically directed them that if they fail to produce him, in default, they have to attend court to show cause. So we all agree there is no production, but I can see they are not here. I'm only seeing Mr. Marwa. He's not the DCI, he's not the IG. So if we are operating under the rule of law, at the very bare minimum, the 2 gentlemen should be in court doing the explanations which counsel is purporting to do from the back. Because underlying all this is the liberty and the life of a citizen at stake. We may speak all the English, but there is an individual whose life and liberty is at stake at the end of the day. And that should be the primary concern of all the parties and the law. And in furtherance to that limb, my Lord, Mr. Ndiangui seemed to have only attracted the attention of the respondents.
That is the second petition.
The second petition seemed to have only attracted the attention of the respondents on the 18th of June.
On the 18th.
18th of June 2025, and that is, my Lord, as per the annex 10, the replying affidavit, page 10. Sorry, on the 19th of June. 19th of June, as per the annexure found at page 10 of the replying affidavit, is a letter signed by one Zachary Kariuki, the DCI Operation Support Unit. And that letter, my Lord, it is the first time that the question of liberty of the second petitioner is being discussed. Before that day,
You are referring to
page 10 of the replying affidavit of the respondents,
that item is
it's a letter dated 20th of June.
that item is
It's a letter dated 20th of June.
that item is
It's a letter dated 20th of June.
that item is
It's a letter dated 20th of June. They are its residents, as confirmed. It walks like a duck. It can only be a duck. And in their replying affidavit, they are speaking to recoveries of items in his house, confirming presence in the scene. They are not speaking to investigating or finding this man, the substance of this habeas application. If they were really minded to protect the fundamental rights of the second petitioner, and if they didn't know where he is, the report to court today will have been the number of witnesses they've questioned, the track and trace they have deployed, the CCTVs they have seen around the scene, to explain the whereabouts of a Kenyan who they will have said they took in their custody. But to the extent they are not talking about that, they are only talking about the items they've recovered and a purported expose. We can only conclude they have it. And those are the questions. If the orders of this court issued yesterday were complied with, we will be asking the two gentlemen and their subordinates